Hello, everyone, and welcome to Adam and Reese's Financial Services webinar series. I'm Sandra Claudio, a Business Development Manager in our Tampa office. I would like to welcome you to today's webinar on the Fair Credit Reporting Act, litigation trends and changes in light of the COVID-19 pandemic. With me today are my colleagues Lyndey Bryant from our Columbia, South Carolina office and Chantal Pillay from our Tampa office. Lyndey and Chantal both practice in the firm's litigation practice group and routinely handle cases involving financial services, including commercial and consumer litigation. Through their work, Lyndey and Chantal have defended clients against alleged violations of the Fair Credit Reporting Act, Fair Debt Collection Practices Act, State Unfair Trade Practices Act, and Telephone Consumer Protection Act. They're also members of the firm's financial services team. Just a little housekeeping before we get started. We would love to hear from you today. If you have any questions during the presentation, please type them into the question box in your control panel. We will have time to address questions at the end. Also, we are recording the program today, and we'll be sending you an email with a link so you can share the content with your colleagues. We will also send a copy of the slides to you. The program has been pre-approved for 1 hour of CLE credit in 7 states. And we will be submitting your attendance with state bars as indicated on your registration form. A certificate of attendance will also be provided to attendees. Now, I will turn it over to Lyndey Bryant.
Thank you, Sandra, and good afternoon to everyone on the call. Although many of you are probably familiar with the Fair Credit Reporting Act in general through your business or personal experience, we just wanted to briefly go through the framework for the Act as a point of reference for our discussion later of the CARES Act changes and litigation trends that we're seeing. The Fair Credit Reporting Act was first appeared in 1970. The purpose of the Act is to ensure fairness, accuracy, and privacy of personal information. And the original version of the Act only applied to credit reporting agencies. Certain amendments in 1996, 2003, and 2010 expanded statutory rights for consumers and brought furnishers and users of consumer credit reports within its purview. As we've seen over the past few months, consumers' ability to access credit during an economic downturn is significant. At the same time, for many of you on the call, creditors and other financial institutions also have a strong interest in being able to access timely, accurate, and significantly correct credit information from consumer reports when making decisions on issuing credit. Obviously, since 1970, and even more so in the early 2000s, consumer credit information has become digital and really has increased exponentially. As you'll see from the numbers on the screen, the federal government estimates that there are 200 million consumers in the United States, and that the big 3 credit reporting agencies, Experian, Equifax, and TransUnion, receive 4 billion updates of information each month from more than 30,000 furnishers. Those numbers were quite astounding to me and probably to you too if you haven't seen them. The FTC estimates that 1 in 20 consumers have a credit report error that will lower their credit score. So these numbers really create the why for the Act, and as we'll see, make this statute ripe for litigation by consumer plaintiffs, especially those with a credit report error. The Fair Credit Reporting Act provides consumer rights to access correct data. It imposes obligations on users of consumer credit reports to notify consumers when adverse decisions are made, and imposes duties on consumer reporting agencies to protect data and only to provide reports for a permissible purpose. Significantly, for many of you on the call who likely consider yourselves furnishers and users of consumer credit information, the Act requires you to maintain accurate information, investigate disputes, and pull credit reports only for a permissible purpose. So briefly, what is a consumer report? As you'll see on the screen, which I'm not going to read through for you, a consumer report is very broadly defined by the statute. Examples of information that's included in a consumer report are when a consumer first opened his or her credit account, the amount of available credit, the amount of credit that's actively being used, outstanding debt collections, details on public records, judgments, bankruptcies, tax liens, and foreclosures. Significantly, what is not in a consumer report? Obviously, any information that does not bear on any of these 7 characteristics, for example, previous addresses, dates of birth, social security numbers, information that identifies a consumer. Even if this information is in a consumer report, it's used only for the purposes of verifying identity of a consumer and does not factor into that consumer's credit score. This is important because some previous addresses, may be in a low income area or other, defining characteristics. Consumers sometimes don't understand that information is not bearing on their credit score, even if it's being reported. A number of times they want that information removed and simply stated that information is not governed by the Act. Not all debts must be reported or included in a report. And as we'll see in a few minutes, there is no obligation under the Act for furnishers to report consumer credit information. Only once that obligation is voluntarily undertaken do statutory duties arise under the Act. So if not all debts need to be reported, I think there's often some misunderstanding by consumers that positive debts or debts that they're actively repaying are not showing on their report. Debts that a consumer is actively repaying might positively affect their credit score. And so a number of consumers will get upset or mad or try and file a dispute when those debts are not showing on their credit report. However, an unreported debt is not a violation of the Act. Negative credit information has to be removed from a credit report after 7 years. The only exception to that is debts that are discharged in bankruptcy, which are removed after a period of 10 years. So even though there is an obligation for negative credit information to be removed, accounts that are in good standing or that have been voluntarily closed are not necessarily negative. Therefore, that information may not have to be removed ever. A report, the other thing a lot of consumers don't understand is that their reports across the big 3 credit reporting agencies are not necessarily identical. Experian, Equifax, and TransUnion do not obtain information from the same sources, or if they're from the same sources, not necessarily do they get the information at the same time. So there's always some level of variance in what shows on a consumer's report. And frequently we see complaints by consumers that their credit reports are not the same and their scores may be different across the big 3 credit reporting agencies. As long as the information is not inaccurate or incorrect, small differences in what is reported is not a violation of the Act. So, who is regulated by the Act? There's really 4 categories of information of persons and entities who are regulated by the Act. The first, again, the original purpose of the Fair Credit Reporting Act was to regulate credit bureaus, also known as credit reporting agencies. These are companies like the big 3 that we discussed earlier that collect, compile, and maintain individual credit information. The purpose of their maintaining that information is to provide it to users, so long as those users have a permissible purpose, which we'll discuss briefly in a minute. The second big category are specialty agencies. These are entities that sell specific information about a consumer. For example, check writing history, medical records, or rental history. The third category, which I would expect many of our participants today fall into, are furnishers. These are individuals or organizations whose business is gathering and reporting consumer credit information. Their purpose in reporting that information is so that others can use it in making a decision whether to grant credit, underwrite insurance, or potentially, as we'll discuss, employ a consumer who's applying for a job as an applicant. Finally, the potentially largest category of people who are regulated by the Act are users. Users are individuals or companies who obtain and use consumer reports for credit, insurance, employment, housing, or really any other purpose as long as it's permissible under the Act. So briefly, I want to take a poll. Okay, if you have not yet submitted your response, please do so. I'll close it out shortly. So it looks like the majority of our participants would consider themselves to be furnishers. 73% of our audience would consider themselves furnishers, and 45% of you would consider yourselves to be users. Thank you. So I want to briefly go through the statutory requirements of credit reporting agencies. Even though none of our attendees consider themselves to be a credit reporting agency, it's very important to understand how each of the different groups interrelate to each other with respect to their statutory duties. First, and perhaps most importantly, a credit reporting agency is required to adopt reasonable procedures for maintaining consumer credit information. The language from the statute is on the screen, and really this requirement to adopt reasonable procedures applies to every category of persons and entities that are governed by the Act. In general, a credit reporting agency does not violate the reasonable procedures duty as long as they report debts that are furnished to them by creditors. So this certainly puts the onus on furnishers of consumer credit information to ensure that they're reporting accurate and correct information to a credit reporting agency. Credit reporting agencies must also provide a credit file to a consumer upon request, as well as certain statutory disclosures. A consumer has a right to their credit report once a year for free. The importance of that is the credit report shows every furnisher who's provided consumer credit information to the reporting agency, and also discloses all of the users or individuals or entities who have pulled the consumer's credit report. The significance is that furnishers and users cannot hide. In other words, if you're reporting information or using a consumer's credit report, the consumer will know. And that gives the consumer the ability to file a dispute or challenge credit reporting information that's been provided by a furnisher, or potentially to challenge a user who's pulled their credit report. Consumer disclosures are also required by a reporting agency. These disclosures include the consumer's file, the sources of information, identification of all users, the dates, payees, and amounts of checks upon which any adverse characterization of the consumer is based. So if there is any information on their report which is negatively affecting their credit score, is available in their file. There's also a disclosure of all inquiries received within a 1-year period. There are certain users who are able to pull a consumer credit report without the consent of the consumer, as we'll discuss. And so there is a list of inquiries on the report that the consumer can access. Credit reporting agencies have an obligation to reinvestigate after receiving a consumer dispute. The required period of time to conduct the reinvestigation is the same for both credit reporting agencies and furnishers, and that is 30 days. There is an ability to extend that deadline by 15 days if new information is received. However, a credit reporting agency and a furnisher is not required to reinvestigate disputes that are determined to be frivolous or irrelevant. And we'll discuss those in a minute, but in essence, if the consumer has failed to provide enough information to enable the furnisher or credit reporting agency to investigate the dispute, or appears to be a blanket dispute covering almost everything in the file, then there is no obligation to investigate. Credit reporting agencies who receive a dispute from a consumer must promptly notify the furnisher to request that the furnisher investigate the dispute. Many of you are probably familiar with the form. It's a credit dispute verification form, or CDV, that the credit reporting agency submits to a furnisher requesting information in order to verify the accuracy of a reported debt. In response, the furnisher has their statutory obligation to investigate the dispute by checking records in their file, reaching out to the consumer for additional information, and completing their investigation within 30 days. After finishing their investigation, the furnisher responds to the credit reporting agency with a universal data form, or UDF, which notifies the credit reporting agency if the debt is accurate or if it should be deleted or modified. A third option is if the debt cannot be verified, in which case it is removed from the consumer's credit report. Credit reporting agencies must allow consumers to add an explanatory statement to their report if they are dissatisfied with an item of information that has been verified to be accurate or correct. Finally, credit reporting agencies are required to ensure that anyone who pulls a consumer credit report has a permissible purpose. And this obligation that you have a permissible purpose extends to users who request a consumer credit report, as we'll discuss. What is a permissible purpose? There are quite a number of permissible purposes under the statute, and one that is extremely broad, as you'll see in about the middle of the slide, is an other legitimate business need for information. The Act does not impose any liability on a user who obtains a report under what they reasonably believed to be a permissible purpose, even if it turns out later by court order or otherwise, it determines to be impermissible under the Act. So that's important, because for anyone who considers themselves to be a user who frequently pulls consumers' credit reports, as long as you have a reasonable good faith belief that you have a permissible purpose, one of these itemized purposes on the screen, then generally speaking, you will not have liability imposed against you absent any other knowledge or reason to know that the purpose is not correct. Although there are quite a number of permissible purposes listed on this slide, perhaps the most relevant ones to those of you calling in are a court order or subpoena, written instructions from the consumer, a credit transaction involving the consumer, and underwriting of insurance involving the consumer. In particular, for lenders and other financial services providers, there are two purposes which frequently come up. First, the evaluation of a consumer applying for an extension of credit, and the written instructions of the consumer. In several recent cases, there have been questions of whether a consumer can limit a business's permissible purpose. So, for example, in a recent case, there was a consumer who directed an auto financer to only run her credit with one lender, and that one lender was one that she was pre-qualified with. The financer instead submitted the application to multiple lenders, which resulted in several inquiries on the credit report, which affected her credit score. The financer asserted that they had two permissible purposes. First, that they had the consumer's written consent to run the credit with multiple lenders, and second, that they were involved in a credit transaction. So the court held that the consumer did appropriately limit the business's right to pull the credit, but because there was a secondary or parallel permissible purpose, then the consumer's attempt to restrict the access to the credit report really did not create any liability for the business. The takeaway of this case, for many of you on the call, is that you should be careful when you are obtaining a consumer's consent to pull their credit report or use their consumer credit information. If the consumer is limiting their instructions, you ought to make sure that those limitations are documented in the file, and that any other parallel permissible purpose listed here, whether it be a credit transaction involving the consumer or some other legitimate business need, that you document it in the file if it turns out that you're using their credit information in a way that is outside of their limiting instructions. In addition, you should make sure that you have clearly defined internal policies and procedures, as well as employee training regarding consumer consent. when you have those sort of policies and procedures, you ought to make sure that you're correctly documenting what your permissible purpose is from the outset, rather than relying on employee representations after the fact, particularly if you're defending litigation involving a violation or alleged violation of the statute. As to furnishers, there are a number of similar obligations to what we saw for the credit reporting agencies. Again, I want to reiterate that the Act does not place any obligation on furnishers to report credit information to reporting agencies. It's only after you take on that obligation do the statutory requirements begin to take effect. When reporting consumer credit information, furnishers are required to ensure the information is accurate, correct, and updated as necessary. Under several cases that have discussed a furnisher's obligations, courts have determined that furnishers have reasonable cause to believe the information is inaccurate if it has specific knowledge other than solely the allegations by the consumer that would give the furnisher substantial doubts about the information's accuracy. So that's a pretty high standard. It's a reasonable, good faith basis, as long as you don't have specific knowledge to believe, to give you substantial doubts about the accuracy, do you run afoul of the statute. Currently, this is also important, consumers do not have a private cause of action against furnishers for reporting inaccurate information. The remedy that a consumer has if a furnisher reports inaccurate information is to file a dispute with the furnisher or with a credit reporting agency. It's only when a furnisher fails to investigate or fails to timely investigate a dispute or continues to report inaccurate information after completing a dispute that liability exists under the statute. There are several specific items of information that need to be provided to a credit reporting agency when a furnisher is reporting a consumer's credit information, and that includes credit limits, disputed information. So once a consumer disputes information, a furnisher cannot continue to report that information without disclosing that the information is actively in dispute. Closed accounts need to be provided to a credit reporting agency. This is important because some users may interpret a closed account as an indicator of bad credit, even if it's been voluntarily closed by the consumer. Closed accounts also factor into the amount of time that they can be on the credit report. As for delinquent accounts, the date of delinquency must be reported within 90 days. This is important because the date of delinquency determines how long the debt can be reported. Again, negative credit information must be removed from a credit report after 7 years. And again, the exception is for any debts that are discharged in bankruptcy, which can be removed or which can stay on a credit report for 10 years. Again, I think what the takeaway really here is that our furnisher clients should have policies in place to make sure that credit information that is being reported is reviewed periodically and updated as necessary. You need to make sure that information provided to credit reporting agencies are associated with the right person. And oftentimes, I think the best rule of thumb is to make sure when you're reporting consumer credit information that it's for the right person, it reflects the terms of the account, the consumer's performance on the account, and that the date, the time period in which you're reporting is clearly set forth on the documents that you're submitting to the credit reporting agencies. It's also important that you establish internal controls for making sure that you're reporting accurate information. For example, random sampling. You certainly could check your documents to make sure that for consumers on whom you're reporting credit information that is accurate. To the extent that your random sampling turns up any consumer credit information that's inaccurate or incomplete, it gives you the opportunity to delve a little deeper by checking individual files. You also want to prevent re-aging of consumer credit information, and that is inaccurately changing the date of the first delinquency on a credit account to a later date. You also want to make sure that if there is a consumer credit dispute that turns out to be correct, that it's not continuously being reported on a consumer's credit report. Furnishers are not required to investigate frivolous disputes. And that's important because there are really a huge percentage of disputes fall outside of the duty to investigate and are considered under the statute or federal regulations to be frivolous or irrelevant. Again, just like we talked about for the credit reporting agencies, that occurs when a consumer is not providing sufficient information to identify the account in dispute, the information is a blanket dispute, or there's simply not enough there for you to investigate. In that circumstance, a pro forma response is appropriate. I think in this day and age, when a number of consumers are sending in consumer credit disputes, there's kind of a knee-jerk reaction, a sense that you should be investigating every single one of them. Our furnisher clients should have policies and procedures in place so that they're not investigating what are otherwise frivolous or irrelevant disputes under the Act. Once a furnisher client does receive a dispute which it believes it needs to investigate, you should conduct a reasonable investigation. The reasonableness of an investigation is not defined by the statute. Instead, our courts have determined that it varies based on the circumstances, including, for example, whether the furnisher is the original creditor who may have more substantiating documents in their file, or a down the line debt buyer who may have less interaction with the consumer and less access to the original substantiating documentation. The scope of the investigation is not exceedingly broad. Instead, it's limited to the scope of the dispute that you receive. Furnishers, once they complete their investigation, and again, they have 30 days or 45 if extended by receiving additional information, are required to report the results of their investigation to the credit reporting agency and to the consumer. At that point in time, the furnisher has the opportunity to correct or modify or delete the information that is, that they're reporting. They also have the opportunity to say that the information is not verifiable. Finally, there are statutory requirements of users of consumer reports, including the primary obligation on users is that they have a permissible purpose for obtaining a consumer credit report. Once the report is obtained, the following statutory duties on this slide begin to kick in. A user must maintain reasonable procedures to ensure compliance with the Act, and they must notify a consumer when any adverse action as defined in the Act is taken. Mortgage lender clients, users in particular, must disclose to the consumer as soon as reasonably practicable a copy of the information obtained and the consumer's credit score. Users of a consumer report in connection with providing credit must provide a notice to the consumer in the form and manner required by the statute. And that form is set forth in the statute at section 1681 MH5. Finally, a user must dispose of consumer credit information in a secure manner, and that extends to written consumer credit information and digital information. Very briefly, I want to focus on specific employer user duties under the Act. Many businesses on this call who may consider themselves furnishers or users in some other context may also be a user in the context of being an employer. Many of our clients and many employers in general use background checks to make sure they're hiring the best candidates. Using a background check on your employees or on applicants for employment does bring you within the purview of the Fair Credit Reporting Act. The Act governs all employment background checks which do constitute consumer reports, even if they don't contain credit information. So, in order to comply with the Act, an employer must provide an applicant with a separate document that contains a clear and conspicuous disclosure, and an employer must obtain the applicant's written authorization to run a background check. The wording and formatting of the required notice are specifically set forth in the statute. If an employer decides it's going to take any adverse action against an applicant or current employee, then the employer must send a notice to the applicant, a copy of the report, and a summary of the rights to the applicant prior to making the adverse action. In addition, the employer must wait 5 days to take any adverse action, and after the adverse action is taken, the employer must send a notice containing certain information set forth in the statute. Finally, really just to summarize, there are so many rights that the Act provides to consumers. A lot of them are included on this slide, and it's important for all of our clients, whether you be a credit reporting agency, furnisher, or user, to understand the scope of these consumer rights in order to ensure your compliance with the Act. One that I just want to very, very briefly bring to your attention is that consumers can obtain their credit report once a year, which again lists all furnishers and all users. They can obtain their credit report more than once a year if they are unemployed and planning to start a job search within 60 days. This one is particularly important during the time period we're in, as so many people are unemployed at this time, nationally speaking. Consumers on welfare or a victim of identity theft may also obtain additional reports. At this time, I'm going to pass the mic over to Chantal to discuss recent changes to the Act as a result of the pandemic.
Thank you, Lyndey, and hi everyone, and thank you so much for joining us this afternoon. I am going to be talking to you all today about the CARES Act and how it affects the Fair Credit Reporting Act. So the CARES Act, what is it? I'm sure you are all familiar with the CARES Act in some aspect, whether it's in your personal life, business, or at your job even. It's the Coronavirus Aid, Relief, and Economic Security Act. It was enacted on March 27, 2020, and it was in response to the economic fallout due to the COVID-19 health pandemic. It provides emergency assistance to consumers and businesses affected by COVID. So it's in effect from January 31st, 2020, so it is retroactive, until the latter of 120 days after enactment or 120 days after the end of the National State of Emergency Declaration. There are several portions of the CARES Act that directly impact how financial institutions furnish consumer information to credit reporting agencies. Specifically, Section 4021 of the CARES Act amends the Fair Credit Reporting Act to address how financial institutions or furnishers should engage in credit reporting through the ongoing COVID-19 pandemic. So on April 1st, the Consumer Financial Protection Bureau issued a policy statement. Oh, Lyndey, next slide, please. Thank you. The CFPB issued this policy statement on April 1st regarding the Fair Credit Reporting Act in light of the CARES Act, in which it acknowledged that there are these challenges that furnishers and consumer reporting agencies are currently facing due to this pandemic. Challenges such as a reduction in staff. Many employees, families, and friends that you all know out there have lost their job or have been furloughed during this time. I know there's entire financial institutions that are actually still working from home and are doing so for the foreseeable future. This creates difficulty in intaking disputes as there's a lack of access to necessary information, which has led to and will continue to lead to the inability to investigate consumer reporting disputes within the timeframes set forth in the FCRA. So the CFPB has issued this guidance in light of the CARES Act, recognizing the serious impact that COVID-19 has had on the industry. What does this policy statement address? Next slide, please. In the statement, the CFPB states that it will allow consumer reporting agencies and furnishers to take longer than the established deadlines to investigate consumer disputes where significant operational disruptions related to COVID-19 have impacted the consumer reporting agency or the furnisher's ability to timely investigate these disputes. So if you recall from Lyndey's presentation, the time frame to investigate is 30 days, and it may be extended another 15 days for up to 45 days if a consumer provides additional relevant information. Well, in this statement and in this guidance, the CFPB has now provided some flexibility, stating that it will consider the individual circumstances of the consumer reporting agency or furnisher in failing to meet these statutory deadlines. It intends to consider the circumstances that entities face and their good faith efforts to comply with the statutory and regulatory obligations as soon as possible, even if that investigation takes longer than the statutory time frame. In this policy statement, the CFPB has not set any definite time frame, so there is no 45 days, 50 days, or longer, but rather, as I mentioned, it's now a good faith standard. And it is, the CFPB is going to afford this flexibility moving forward. And in evaluating compliance with the FCRA as a result of the pandemic, the CFPB has stated that it will not bring an enforcement action where the consumer reporting agency or the furnisher made this good faith effort to investigate the dispute as quickly as possible. Again, even if that takes longer than the statutory requirements. The second part of the statement, the April 1st statement, the CFPB encourages furnishers to offer payment flexibility to their borrowers affected by COVID-19, and it addressed how furnishers report accounts that are subject to an accommodation as defined by the CARES Act. So what is an accommodation under the CARES Act? Let's stop here for a second. I'm going to pose a poll to you guys. Which of these is considered an accommodation under the CARES Act? I'll give you just a few more seconds. Okay, Lyndey, do you mind going ahead and closing that? Let's see what the answer is. All right, great job, everyone. 78% said all of the above. That is correct. It is all of the above. So an accommodation under the CARES Act is any payment assistance or relief granted to a consumer who is affected by the COVID-19 pandemic. This includes voluntary payment assistance or even those granted pursuant to statutory or regulatory requirements. And I'll discuss later on, but there is actually a regulatory requirement in the CARES Act for accommodation. Accommodations includes, as you saw before on the polling question, agreements to defer one or more payments, to make partial payments, to forbear any delinquent amounts, or to modify a loan or contract. Really, it's any alteration to a consumer payment agreement offered to someone affected by COVID-19. So what are the reporting obligations for a furnisher that provides an accommodation or a payment assistance? This is very important for furnishers to understand their obligations under the CARES Act as it relates to accommodations. I'm sure there's been a large amount of payment relief agreements due to COVID-19 that have occurred, and that probably will occur since this is an ongoing situation. First, if an accommodation is made, the Act requires furnishers to report the debt obligation to credit reporting agencies as current, if that obligation was current as of the date of any modification. So for example, say that a borrower lost their job and they called their lender and they let them know, I lost my job due to COVID-19 and they need some sort of assistance. At that point, they are still current in their obligation. So if there is some sort of payment relief plan or accommodation, the reporting needs to stay as current to the credit reporting agencies. Second, if the credit obligation was delinquent before the accommodation, the furnisher can maintain the delinquent status during the period of the accommodation. However, the furnisher cannot advance the delinquent status. If during the accommodation the consumer brings the obligation current, then the furnisher must report that credit obligation as current. This could occur, for example, if the accommodation itself brings the credit obligation or account current, such as a loan modification that resolves the amounts past due so that the borrower is no longer considered delinquent. And just a little side note here, but this does not apply to charged off accounts. So on the next slide, I have a few examples. First, if at the time of the accommodation, the furnisher was reporting the consumer as 30 days past due, then during the accommodation, and we'll say after an additional 30 days, the furnisher cannot report the account as 60 days past due. So just as a reminder, the furnisher cannot advance that delinquent status, even if they're reporting that account as delinquent because it was delinquent prior to the accommodation, they cannot advance that date. Second, if the borrower enters into a loan modification that resolves the amounts past due, or if the borrower makes payments that brings the credit obligation or account current, which means the borrower is no longer delinquent, then the lender must report the account as current. And that's just a reiteration of what I mentioned before. And also just a good place to note here, remember that the CARES Act, although it was enacted on March 27th, 2020, it is retroactive. So it goes back to January 31st, 2020. This means that furnishers should update their information furnished in February or early March of this year prior to the enactment of the CARES Act, where accommodations were offered during that time period due to COVID. Again, just a reminder, the CARES Act is in place for until the latter of 120 days after enactment or until 120 days after the declaration of the state of emergency. How do you report the status of an account after the accommodation ends? So the CARES Act continues to apply to the time period that was covered by the accommodation even after it ends. This means that a furnisher cannot report a consumer that was reported as current pursuant to the CARES Act as delinquent for the time period that covered the accommodation after the accommodation ends. Again, just a brief reminder, the CARES Act applies retroactively, so make sure to go back and check out those February and early March accommodations. So does the CARES Act require furnishers to provide an accommodation? Well, the CFPB generally encourages furnishers to provide flexibility to consumers and debtors and payment obligations. It is only required for two specific types of loans. The first is a federally backed mortgage loan. Under the CARES Act, a borrower may obtain a forbearance from their mortgage servicer upon request due to the financial hardships created by COVID-19. And this is in section 4022 and 4023 of the CARES Act. Second is federally held student loans. The CARES Act provides for automatic suspension of principal and interest payments through September 30th, 2020. Those are the only two situations where furnishers are required to make accommodations. Other than that, the CFPB simply encourages lenders to make these efforts to assist borrowers with payment relief and provide accommodations. Additionally, while the CARES Act expands the obligations of furnishers under the FCRA, it's important to note that it does not create any new claims under the FCRA. Rather, furnishers' actions and compliance and essentially their potential liability continues to be measured under the standards of willful noncompliance and negligent noncompliance as set forth in the FCRA. So best practice. The best practice to avoid liability is for furnishers to make a good faith attempt to actually meet the statutory timeframes set forth in the Fair Credit Reporting Act. Despite the fact that the CFPB has stated it will allow this flexibility, it's better to just try to meet those deadlines. And that way you're not running up against this, this ambiguity of what good faith is. However, in the event that a furnisher cannot meet those statutory timeframes, then you should document your attempts to comply and the difficulties you've encountered in trying to meet those statutory deadlines. So whether it be those challenges that we spoke of before, such as a reduction in staff or working from home, or even an increase in claims. And now that, entire financial institutions are working from home, there's a lag in mailing and getting those disputes to you, which has created difficulties in meeting the time frame. Document, document, document. That way you can show that you've made a good faith effort to actually meet those statutory timeframes and you've completed the investigation as quickly as possible under your unique set of circumstances. Additionally, Furnishers should update their procedures concerning how to report accommodations to comply with the requirements of the CARES Act, including applying those procedures retroactively if necessary. So finally, the CFPB has some great resources on their website. In addition to the April 1st, 2020 policy statement that was issued, there was actually also issued a compliance aid in the form of a frequently asked questions. It includes great information. It's available on their website. I don't have a link on these slides, but I believe we're going to be sending out this outline and this presentation afterwards, and there will be a link to the CFP website that includes that information. So that's all I have about the CARES Act today and its effect on the FCRA. Thank you all for listening. I'm going to turn it back over to Lyndey now to discuss identity theft and enforcement.
Great, thanks, Chantal. I am not going to go through the identity theft provisions. I think we'll probably share our PowerPoint presentation with all of you participating on this webinar, and so you can look at these provisions yourself. Suffice it to say, identity theft affects more and more consumers every single year. As many of our business clients are aware, data breaches and phishing and other fraudulent efforts are just increasing dramatically, and unfortunately it's probably the new normal or way of the future. So identity theft provisions are obviously covered by the Fair Credit Reporting Act, and it's very important whether you're a furnisher or a user to understand obligations that are triggered once a consumer reports identity theft. Many of you are probably on here today because you want to know how to minimize or avoid potential litigation under the Fair Credit Reporting Act. The fact of the matter is litigation under every single federal statute is increasing, and that goes for the Fair Credit Reporting Act as well. Under the Act, the Fair Trade Commission retains primary enforcement authority for pursuing any businesses or individuals that knowingly violate the statute. A knowing violation is defined as committing a pattern or practice of statutory noncompliance, and there are civil penalties. State agencies may also pursue administrative enforcement of the Act. It's rare for state agencies to pursue administrative enforcement, but that's probably changing in light of the CFPB's policy statement, as Chantal just reviewed with you. There are restrictions on state agencies and bringing litigation under the Act. Any state agency seeking enforcement must notify the federal government and allow the federal government to participate. And in addition, state agencies are required to first seek injunctive relief, not monetary relief in the first lawsuit. It's only after a state agency obtains injunctive relief and further violations occur, may a state agency then pursue subsequent litigation for monetary relief. Again, because of these restrictions, plus budgetary issues that state agencies deal with, state agencies rarely file suit to enforce the Act. As Chantal mentioned, the CFPB has indicated that it's likely to be somewhat lenient on furnishers and users in enforcing their dispute investigation requirements. In response to the CFPB's policy statement, a group of 22 state attorneys general on April 28, 2020, sent a letter to the consumer reporting agencies indicating that consumer protections are more important than ever in this economic recession, and warning that states will enforce federal and state requirements, including the Fair Reporting Act. Although that letter was addressed to the credit reporting agencies, furnishers and users should take caution from that letter and ensure that they have reasonable policies and procedures in place that are consistent with current law as that changes. The Act does impose criminal liability against entities and individuals. Under the criminal liability sections, there's restrictions on obtaining credit information under false pretenses, and also, restrictions and penalties on users who disclose consumer credit information without authorization. Civil liability under the Act is very broad. Many circuits, many federal courts have found that the Act can be enforced privately if a willful or negligent violation of merely OMO subsection subsection of the Act occurs. The number of Fair Credit Reporting Act lawsuits has increased every single year since 2011. We anticipate that litigation will continue in light of the pandemic and the economic recession, especially in light of the growing unemployment rate and credit accommodations, as Chantal discussed with you. The primary lawsuits that we see, most consumer plaintiffs will allege negligent and willful noncompliance in the same lawsuit, but generally speaking, most of the willful noncompliance claims tend to drop out fairly early. As is probably expected, most consumers don't really know what's going on behind the scenes, and so they assert both negligent and willful noncompliance, and then in discovery typically find out that there's just not enough evidence to find a willful violation. In order to state a claim for negligent noncompliance, a plaintiff must show that the defendant was negligent in failing to follow reasonable procedures. A lot of times those negligent noncompliance cases boil down to internal inconsistencies or policies that simply aren't being followed. There is insufficient training for employees to understand the policies and procedures that the business has in place. In addition, for credit reporting agencies, there can be a negligent noncompliance case where a classification system results in misleading information, and that could potentially apply to furnishers as well. Generally speaking, the most important obligation for our furnisher clients is to properly and completely investigate a dispute when they receive notice of a dispute from a consumer. Furnishers are generally liable under the statute if they fail to conduct a reasonable investigation, fail to meet the statutory time obligations for completing the investigation, and failing to accurately report the results of their investigation. Willful non-compliance with the statute generally is found where after a dispute is completed and the furnisher determines that credit information is not accurate or not correct, and they continue to report that information. Liability has been found for willful noncompliance with the statute where that occurs. And a lot of times that occurs without the intention to do so. Instead, it's a situation where the left hand doesn't know what the right hand is doing. For example, if you have a level of employee that is reporting consumer credit information and a different level of your business that is reviewing and investigating consumer disputes, you need to make sure that everyone in your organization who's got their hands on consumer credit information knows what everyone else in the business is doing. Users can be found liable under the statute where they are requesting consumer credit information without a permissible purpose. Again, it's important to remember that as long as a user has a reasonable basis to believe they have a permissible purpose, then the fact that it's found later to be impermissible does not create liability for users. In addition, users who obtain consumer credit information and improperly disclose it to third parties can be found liable under the statute. In order to be liable for willful noncompliance, a consumer must show that the defendant knowingly, intentionally, or recklessly committed an act in violation of the statute. Finally, damages. The Act does require a plaintiff to prove damages. Therefore, purely technical claims, for instance, you just didn't send me the required notice, generally speaking, is going to be subject to early dismissal. Now, damages do not have to be out of pocket. In other words, they don't have to be obtaining credit on worse credit terms. Instead, a consumer can prove damages through emotional damages alone, such as humiliation or mental distress. I personally hate that kind of damage. It makes me cringe, but unfortunately, consumers have received awards for mental distress, for example, for humiliation, embarrassment, etc., resulting from credit denials or lengthy dealings to correct their report. Consumers can also recover attorney's fees. There are penalties under the statute in private cases, and in a willful noncompliance case, a consumer can also recover punitive damages. So to wrap up, and I want to just remind you all that we will take questions. We may have to follow up with you given our time constraints. We want to get everyone out of here in an hour. But if you have questions you'd like Chantal and I to answer, please feel free to submit those using the Q&A function. Just to wrap things up, we want to leave you with some practical takeaways. We recommend that your business adopt and uniformly implement reasonable procedures. Again, this is the most important requirement for every single category of persons and entities under the statute. You need to have reasonable procedures for collecting, maintaining, reporting, and verifying consumer credit information. Your policies need to be regularly updated to take into consideration changes in the law. And certainly there are numerous attorneys in our law firm who can help you implement and create policies and procedures that comply with the law. When you report consumer credit information as a furnisher, that information really should be substantiated by your records at the time it's furnished. You should have layers of employees who are double checking and verifying the information before it is reported. The information that you report should include consumer identifiers, such as names, date of birth, social security numbers, telephone numbers, and addresses. And the significance of that is that you're not misreporting debt information for consumers that may be closely affiliated, like spouses or roommates, or guarantors on a debt, situations like that. You want to make sure that the debt is properly associated with the right consumer. Finally, you ought to make sure that the information you're reporting is furnished on a standardized internal form, and that your form specifies the time period that the debt information or credit information pertains to. During the pandemic, and potentially for some period after, as will potentially later be clarified by law, if you're making an accommodation, you need to make sure that that debt is appropriately reported. Don't merely go through the motions as you would in ordinary circumstances. As Chantal mentioned, there may be liability, although it's not clear yet, for misreporting an accommodation as delinquent or charged off or some other negative report instead of current, as the case may be. If you receive a consumer dispute, prioritize your investigation and promptly verify that you're going through and investigating reasonably. You need to make sure the information is correct and update the information if it's not. If the debt is deleted or changed, make sure you have reasonable policies and procedures to make sure it's not reported again. For users on the call, when you request consumer credit reports, it's important that you document all applicable permissible purposes. As I discussed earlier, in as many cases as possible, obtain the consumer's written consent and broad instructions to pull their report. If you have a secondary or parallel permissible purpose, document it. That way, if the consumer claims that their instructions were limited in some way, you can always fall back on another permissible purpose. I just want to remind you here that even if you have a consumer who limits their instructions, you might not be liable under the Fair Credit Reporting Act, so long as you have a secondary or parallel purpose, but you may be liable under state law for breach of contract or potentially unfair trade practices, as the case may be. Finally, when you have consumer credit information and you're destroying it, you need to make sure you're destroying it in a secure manner as to both paper files and digital or electronic files and information. So given that we're at the time for our webinar this afternoon, I'm going to pass the mic back over to Sandra. Again, if you have any questions, Chantal and I would be happy to follow up with you. So please feel free to submit those through the Q&A function or email either one of us. And thank you again for your time. Sandra?
Thanks, Lyndey and Chantal. We would like to thank all for allowing us to present this program to you today and for spending this hour of your day with us. As a reminder, we recorded the session today and we'll be sending you a link along with a copy of the slides and certificate of attendance for CLE credit. In closing, we would like to mention that our firm has produced numerous COVID-19 related resources and information on our firm's website, adamsandreese.com. Content is accessible from the homepage and is organized by subject, including financial services, relief assistance guidance, cybersecurity, employment and business law, and government investigations. Updates can also be found by following the firm's pages on LinkedIn, Twitter, Facebook, and YouTube. Adams and Reese will continue to share the latest developments and provide insights on the impact of COVID-19 across the financial services sector. Thanks again and have a nice afternoon.